of attorneys and the alternative. Let's talk about what a power of attorney is. It's a document that says, if I become incapacitated, I appoint this person to serve in my behalf, or if this person is unable, then I appoint this other person. Usually, if it's drafted correctly, it comes into play when you become incapacitated. What does incapacitated mean? It has a definition within the document, usually the opinion of 2 licensed physicians that you are unable to manage your affairs. It could be that if all of the kids agree that you are incapacitated, or maybe Dr. Smith says so. Whatever you decide, you get to choose who decides your incapacity, and the document will come into play. If that happens, let's say you develop a mental condition or you are in a car accident, whomever you have listed there as the first option can go and act on your behalf, go to the bank, access your bank accounts, pay your bills, make medical decisions, and so on. It is very important to have a medical power of attorney and a financial power of attorney. We draft 2 different ones. Sometimes they're all in one document, because if you don't have them in place, if you don't have a power of attorney, the alternative is an adult guardianship proceeding. What does that entail? Well, your family will likely have to hire an attorney, it's not required, and go in front of a judge and say, hey judge, mom, dad, sister, grandpa, we're in a car accident, they now have Alzheimer's, whatever the situation may be, and they're unable to manage their affairs, appoint me to serve as their guardian. If there is good cause and the judges, if they look at the documents and they agree, if no one is contesting, they will likely appoint the person applying to serve as guardian for the incapacitated person. The guardianship proceeding is no fun. First, it's expensive, even if you don't hire an attorney. Then you have no control over who applies for guardianship. Sometimes if you have 2 or 3 kids, they can all want to serve for whatever reason, or they don't agree, or maybe if you don't have kids, your siblings, your parents can be fighting in court over who gets to make decisions for you. The best thing you can do for yourself, your family, is to make that decision yourself and to put it in writing through a power of attorney. It's so easy to just, for that designated person to go to the bank, here is the document, I'm her power of attorney, as opposed to a guardian going through all this court process and then going to the bank and say, I am the guardian. It's just different, and you have no control over who applies. So be sure to put your wishes in writing, talk to the people, talk to your family. If you are not ready just yet to put it in writing, at least talk to all your family and say, hey, if something happens, this is who I see serving for me, or this is what my wishes are, and hopefully that will diminish the conflict risk. Thank you for watching. Let us know if you have any questions. Be sure to subscribe to our YouTube channel. There's a link right there below. And give us a call if you have any questions. 405-857-8231. Thank you.